Thanks very much, Carla. So unfair contracts, it's nothing really new, I hope, to anyone in this room. I'd hope that you've all heard of the unfair contracts legislation before, particularly in relation to small businesses coming in 2016. The changes that are coming in are what we consider to be some of the most burdensome and concerning changes to the unfair contracts or consumer protection type legislation that we've seen in a very, very long time. And it's something that everybody needs to be aware of, because if you're not, the penalties that you can get hit with are crippling for any business. So I'm hoping it's something you have all heard of and everyone's across and alive to, but I'll run through sort of where things have been at now, because it isn't a new concept. It has been around for about 7 years. It's just the changes and the effect of those changes in terms of penalties and offences that is significant from a creditor's perspective. So I kind of want to keep things as light as I can. I don't want to dive too much into the legal concepts, particularly at 8 o'clock on a Friday morning. It's probably not the most exciting thing to be hearing me talking about legislation or the intricacies of a particular definition. So try and keep it as light as I possibly can. I'm happy to take questions as I go through as well. If you want to put your hand up or anything like that, I'm happy to do that. Carla's got a microphone down the back. So if we want to touch on something while I'm on the topic, I can answer that or take questions at the end. So trying to make it as involved as I possibly can, because it can be relatively dry from a legal perspective. So these are the points that we're going to go through. So where things are at now, what are the key changes, how is it going to affect you, some case studies, things that we've been dealing with, not only over the last couple of years, but what we foresee that you'll likely be dealing with when these changes come into effect, and some lessons and takeaways that you can hopefully take back to your businesses and implement before November this year. So this is very broadly what the regime currently looks like. So as I said, it's been around for about 7 years. November 2016, the 12th of November, some of you may have looked at changing your terms and conditions prior to this date and done an update at that point in time. But what we're looking at is contracts entered into or renewed after that date. It's got to be a standard form contract, and we'll touch on what that exactly means, because it probably means different things to different people. For the supply of goods or services, we're looking at, in this respect, under the competition and consumer legislation, the ACL, there's equivalent type provisions in the ASIC Act that deal with financial services, but they basically mirror what's in the ACL. So if you're providing finance, they equally apply to if you're providing goods or services. One of the parties needs to be a small business. The definition for small business wasn't the easiest to follow. You'd likely struggle, I think, when you were dealing with a customer to know absolutely whether they're a small business or not. So there's been some clarification around exactly what that is and a broadening of that. And the consideration under the contract needed to be either $300,000 up front or $1 million over 12 months if it was something that was going to be running for a period of time. So we dealt with a lot of disputes around whether this actually applied to particular contracts. You'd have a fight with the other side around, are they a small business? What's the consideration under the contract? It was all a bit murky, and it was just easy for other parties to raise it as part of a dispute and make things difficult for us from a litigation perspective. So looking at the terms of what unfair means, and unfair, again, probably has a different meaning to most people and is relatively ambiguous. Some people will look at a term and go, that's unfair. Others will look at it and go, well, no, we need that in our terms and conditions. That protects our interests. So these particular Elements of unfair are what a court considers when they're looking at a particular term, so whether it causes a significant imbalance in the parties' rights and obligations, if the term's not reasonably necessary to protect the legitimate business interest of a party, and whether it would cause detriment to the other side. And I'll go through a couple of terms that have been considered by the courts and let you guys kind of decide whether you think they're unfair or not shortly, based on this definition, if you want to keep that in mind. And these are some of the examples in the legislation as to what terms may be unfair. And it's not an exhaustive list, so you might have a contract with a term that doesn't fall under one of these types of terms. You might also have a term that does and isn't in fact unfair, which makes the legislation very easy to follow. So these are just a couple of examples. It's not an exhaustive list. Some of the key definitions, going back to what is unfair, this is what it looks like under the legislation. I've already mentioned those points in subparagraph 1. When the courts are looking at whether a particular term is unfair, points 1A and 1C are what the customer needs to prove in a court case. 1B, the onus is on the supplier to prove that particular element. So when the court is considering it, the only thing, if you are having the argument on it, that you need to show necessarily is that it's to protect your legitimate interests. And then there's not a lot that the consumer or the customer really needs to do in terms of pointing to whether there's a significant imbalance. A lot of the time that means you can do something, they can't do it, so there's an imbalance there. And ordinarily the element around detriment isn't a particularly difficult one to tick off as well, because you're exercising a right that's usually to their detriment. That's probably why you want to rely on it. So that's an easy one to tick off a lot of the time. What is a standard form? Again, there's just a list of considerations around what that looks like. There's no one size fits all. You don't tick all of these boxes and it falls within it. It's more of just an objective type test, looking at it, does it fit within some of these criteria to say it's a standard form, and some of the changes that have been made make it a little bit easier to identify that, but sort of again broaden the scope of what may be a standard form contract to really capture nearly every contract that you'll probably be putting out there, or terms and conditions. So that's what it is now. And as I said, I don't want to get too stuck on these legal concepts and what it all looks like, but that's what it looks like now. Then we had the Treasury Law Amendment, More Competition, Better Prices Act of 2022 that introduced these new changes. So a summary of them. First key one, it's now an offence to enter into a small business contract that contains unfair terms or seek to rely on a small business contract that contains an unfair term. There's a broader application of the regime by reason of the definitions of what is a standard form contract and what is a small business. So what is going to be captured under this legislation is wider than what it was, and certainly a little bit clearer. And it's very likely that most of the contracts that you have out there will be a small business contract. You'll be dealing with a small business, and then it's just a question of, is it a standard form? And likely it's going to be. So looking at the scope around the changes, this is the changes to the small, like what is a small business. So where at least one party to the contract employs fewer than 100 persons or their turnover's less than 10 million. I think looking at some of the stats around it, that's 99% of small businesses in Australia. So unless you've got a very, very large size company dealing with another very, very large size company, your contracts are going to be caught under the legislation. You're going to be dealing with a small business. So this is going to apply. And there was just a tweak around the employee threshold to further include a reference to part-time staff. There's a pro rata for that. So if you have someone that's working 2.5 days a week, they count as half an employee. That point in red is just an addition to the definition of what a standard form contract is. And what that really is looking at is if you're putting out terms and conditions or you've got contracts with other parties that are substantially the same as what you're looking to enter into, it's more likely then going to be considered a standard form contract, as in you're not renegotiating terms, brand new terms on every single contract. Likely what you're doing is you've got your set of terms and conditions, you're putting them to your customers. There's other customers with the same terms. It then is going to fall under that 0.6 there. And some other considerations around, I think, lawyers who were probably getting a bit creative when these changes came in 2016, telling their clients, just negotiate on the terms, doesn't make it standard anymore. We're giving the customer the opportunity to go, here's the terms and conditions, we'll negotiate on them. That'll bring it outside the scope of what a standard form is, because we'll slightly change some of the things that probably don't actually matter in terms of the substance, but then you look at it compared to any other contract you've got, and unless you're a lawyer and looking very closely at it, it'll probably look almost identical. So these were included, I think, to avoid that sort of a situation where there's an impression that the supplier is giving that we'll negotiate on it that would then fall outside the scope of the regime. So it's just not going to cut it. And again, your contracts very likely will fall under the regime. It's almost inescapable. This is the most significant change and the most concerning aspect for suppliers are the new penalties that have come in. I've got a poll on here. I was going to say I've got fancy QR codes, but I'm happy just for people to scream out or answer this. Does anyone know what the current penalty looks like? And does anyone want to have a crack at what the new penalty is for a contravention of this legislation? Anyone want to pick any number?
100,000.
5 million, 10 mil.
20 mil.
Any others?
100 mil. Give us a clue. Oh, yeah.
What was the highest so far? Was it 20? Yeah, we'll go higher. 50. 50 mil. It's the larger of these as well. So your base is about 50, could be more. And the concerning thing around this is that's per contravention. So you might have a contract that's got multiple unfair contract terms in it. Worst case scenario is you could be slugged that for each contravention, which is a pretty scary thing for anyone to be facing. So that's the most significant change. That's why I think I'm up here talking about it, is because if you don't get it right, this is what the outcome could be. And in saying that, we've seen over the last couple of years, there hasn't been much that the ACCC has done about it. There's been a few cases, but what we might end up seeing is a lot more, and you don't want to be one of those ones caught out on it. So this is the key date, 9 November 2023. I'd certainly be looking to act a lot earlier than then. You want to be ready to go with your terms by that date, because what it applies to is any contract made after the commencement. So things that are on foot now, you're okay. You don't have to go and change your existing contracts that you've already got on foot. If you vary them after that commencement date, they'll come under the regime. If there's a renewal in it that is exercised after that commencement date, the regime applies at the point of the renewed contract. So if you're touching your contracts, you're gonna fall under the regime. But if you've got existing things in place with your customers, you don't necessarily need to go and change everything now, update your terms and send everything out brand new. But it doesn't necessarily mean that you're going to avoid allegations around there being unfair contract terms in your contracts, because the legislation still already exists. It's just the penalties that you probably don't have to be as concerned about. And as I mentioned, we haven't seen a lot of action around these cases, but one of the probably more high-profile ones was this Fujifilm one. Ultimately, where they got to on it was that they settled at a mediation with the ACCC, where they agreed that 38 of their terms across various, like their entire suite of contractual documents were unfair. The orders that were made were to stop them from enforcing those terms across any small business contract that was affected by it. They had to publish on their website a notice saying all of these terms are in our agreements, are unfair, we can't rely on them. They had an order that they implement some training and compliance with their team, and they had to pay about $250,000 of the ACCC's costs on the way through. So a pretty expensive exercise for them, and they initially did dispute it and then ultimately settled it at a mediation and tried to get out of it. But if we're looking at this under the new regime, and the ACCC was to prosecute based on the penalties, if we've got 38 contraventions, we've got a $1.9 billion penalty that they could be theoretically hit with. So again, this is the concerning part of these changes that you need to be alive to. And this is just a sample of some of the terms that were agreed to be unfair. Things like unilaterally being able to change the price, change the terms of the contract, almost anything where Fujifilm could do one thing but then their customer didn't have a reciprocal right. They had an issue around their terms and conditions referring to other terms and conditions that were not easily found, but there's an acknowledgement in the terms that says, I've read these terms and conditions, but the court considered it would be very difficult for the customer to actually track them down to then be able to read them and agree to them. These are a couple more as well. So reading through a lot of these, they're not necessarily terms that they would always be relying on as well. So while these changes are concerning to an extent that there are significant penalties, you don't necessarily need to go as far as what they've got in these a lot of the time to still achieve what you need to do with your contract and have rights that put you in a strong position to deal with any default and make any recovery. It's just not pushing it so far one side towards you that it then ultimately becomes unfair. So any contract can be done in a particular way that is fair and balanced between the parties that still gives you the rights and obligations that you need to necessarily protect your business interests. But that's just a sample of those. Another interesting decision was this particular matter of Lowbucks and Wilshorn, if anyone has come across it. A high-level summary of it is it ultimately was a dispute between two parties around a tank that one party had contracted the other to manufacture. there was a dispute between them around what particular terms applied. There was various quotes that were given, and then it got to a point where the terms and conditions provided to the effect that they would supply this tank within 8 weeks of a deposit being paid. The supplier failed to meet that time frame. Somehow the purchaser ended up with the tank. So the tank went from the supplier to another business to do some small work on it, with the intention that it was always going to be given back to the supplier, but it ended up with the purchaser. Purchaser held on to it. They didn't pay the balance of what was due under the contract and said, we're keeping it. Supplier sues them to get the tank back. They didn't sue them for the balance of the purchase price. They just wanted the actual tank back. And what was raised in a defence and counterclaim by Wilshorn was allegations to the effect that a significant number of the terms in the terms and conditions were unfair. I'm going to run through some of those terms, and I just wanted to get a feel from the audience around whether you think it's unfair or not unfair. And again, I've got fancy QR codes, but I thought we'd just do stand up if you say not unfair, stay down if you say it's an unfair contract term. So this particular term, I'll read it out. At Lobucks's sole discretion, the price shall be either as indicated on any invoice provided by Lobucks to Wilshorn, or the price as at the date of delivery of the goods according to Lobucks's current price list. So let's go not unfair, stand up. Unfair, stay down.
I'll think they'll claim it as unfair.
Unfair? Unanimous on unfair?
Wouldn't it depend also on the type of, if there's other, especially what the tank is made out of? Because I know like more products like resin, copper, things like that, it's based on markets. Because the price, market prices. No, it's okay. I'm quite loud, thanks.
So the question was, wouldn't it depend on what it's made out of if it's specialised? It was pretty specialised, this particular product. It was all custom. Any other thoughts around why everyone is down so they consider it to be unfair?
Just before we go into that, is it the expectation that the clause, if found to be unfair, would be totally struck out and there'd be no substitute? Or is the contract meant to continue without that clause in it, or is there opportunity for the parties to negotiate or substitute a new clause?
Yeah. Under the legislation, the remedy that's available is that the clause is void. So the contract would continue without the clause. And I suppose when you're at this particular point of litigation and a federal court judge deciding on whether it's unfair or not, you're probably not negotiating any further. But certainly,
Just wondering whether or not
if you were
allowed for a substitution after that.
Yeah, there's been instances. I'll come back to this. There's been instances, for example, there was a case, the ACCC and Bendigo and Adelaide Bank, and they also took on the Bank of Queensland as well, where they had a number of their terms, and again, it's by consent. The banks have gone, yeah, we'll put our hands up and we'll say that these things are unfair. What they did in that particular scenario is they proposed to the court variations to these particular terms, and the court was inclined to make orders to the effect that these varied terms are substituted into the particular contract. So there certainly is scope for something like that. I don't think it would happen in a matter where you've got customer v supplier, but in like an ACCC type scenario where you're probably cooperating with them and you want to still have clauses in there that might be necessary to protect your interests without the whole thing going, there is certainly scope to agree on variations, and that's what's been done in some of those banking cases to basically not render their interests and their enforcement ability completely useless.
Sorry, I didn't want to confuse you, but just discerning something like that, I think, in my mind, I need to understand what were the actual practical implications of an unfair clause
Yep.
being found to be
Yeah.
unfair.
Yeah, yep. So it's just gone. If it's unfair, it's gone. And this one, everyone is right, is unfair. Rationale around it is it's low bucks' sole discretion. They can do something without the other side having an ability to take any action in response to it. So the commentary around the court from this is, well, if you're able to vary the price unilaterally, then the customer should have a way out if that's what is the decision that's made to vary it. So being able to do it is not necessarily an issue, but you need to be able to have the customer go, if you're going to vary it, then we've got a right to terminate or something to that effect. So that one was unfair. This one is one that I think most of you would see in your standard terms of conditions. You'd probably call it something like a no set-off type clause. So Will Sean shall not be entitled to set off against or deduct from the price any sums owed or claimed to be owed to Will Sean by low bucks, nor to withhold payment of any invoice because part of that invoice is in dispute. Not fair, stand up. Unfair, sit down. So
I'll use the microphone.
Yeah.
Can I clarify? Sit down if not fair, stand up if fair.
stand up is fair.
Stand up is fair.
So everyone thinks this one is unfair? Fair? Fair? Couple of fairs. Does anyone want to... Yeah. Does anyone want to provide a comment on why they consider it to be fair? Or vice versa, anyone want to say why they think it is unfair?
I'll say why I think it's fair.
Scott from Eggers Automotive. I think it's fair because along the lines if the customer was to go into liquidation or an admin of some sort, that administrator would be asking for that credit to set it off against the debt. So why can't I do it as a business?
Yep.
So I think it's a fair comment,
Yep.
a fair term. Yep.
Anyone else? Any other thoughts? Or even from the other side of the fence? Why?
Set-offs in relation to this particular contract, not
Yep.
a general broader set-off.
Yeah, this particular contract, the price of this contract. So
So this is saying that if the debt is disputed, you still have to pay for the invoice?
yep. So in this scenario, they've got about 50 grand left on the purchase price for the tank. The other side's got what they consider to be a damages claim for the failure to supply within the 8-week period that they say was agreed. Customer says we should be able to set off those damages against the purchase price. We're not paying you for that because we've got this claim, is what it means.
Customers have a right to withhold. So some people might withhold other things. As if I was in that position, I would do that.
Oh. Hello. I said the customers have a right to that. As a customer myself, I would be withholding payment if there was a damages claim and services haven't been provided in full.
And what if they have been provided in full?
Well, there's a damages claim, isn't there?
There is.
So then it's not been in full, has it? If there's a claim.
Yep.
I've got another question for you.
You said at the start of this that the supplier was putting the claim in to get the product back. And that's the premise of all of this, as opposed to claiming the balance. Would it have been a different result if they were only claiming the balance?
Potentially. My overall view on this case is I think it was a bit silly how it was run, in that many of these alleged unfair terms ultimately didn't affect the outcome of the case. So the customer has really just gone through the T's and C's and picked out everything that they say was unfair without actually looking at it and going, what is the effect of this term being declared void and unfair? Does it actually change the outcome of the case? There's only, I think, one or two of them that probably would have affected the outcome of the case, because there's a question around, did the supplier breach the contract by failing to supply within the particular time frame that would then entitle the other side to terminate. But as you say, that the cause of action or the claim for the supplier was, we own this particular good, we want it back. So there was a lot of questions to be answered here that probably didn't need to be answered along the way, and they're relatively complex questions, and the court made comment on that, is that the costs of this action have really been driven up by the customer making these claims around these terms that didn't really need to be answered and had no effect on the outcome. I'll put you all out of your misery. This particular one, they said, was not unfair in this particular scenario, and the rationale behind it, again, looking at when I said that there's three elements of what is unfair, and item B was looking at the protecting the legitimate interests of the supplier in this scenario. The court said or considered that it was completely fair for them to be paid for something that they supplied, and in this case there was no defect claim or any issue with what they had supplied. The customer was using it, they just took it and were using it, and the court said they should have to pay for that. They shouldn't be able to set off, if they've got a damages claim for delay, whatever, they can run that claim, but the supplier shouldn't be out of pocket for, in this particular case where it was relatively custom what they were supplying, they've got to pay for all the cost up front. They shouldn't be out of pocket because then the customer wants to raise some spurious claim. So in this particular scenario, and what I'll say with all of these is, just because it was fair in this case doesn't mean it'll be fair in another. Potentially could be unfair if the
Because in
clause...
this case, there was no defects.
Yeah.
It was just not supplied in time.
Yep.
So if there was a defect with the tank, we're talking about a machine tank or a water tank?
I don't exactly know. I just read tank.
Right.
You guys probably know better about tanks than I do.
Yeah, so I would assume, because if you have defects, you have the right to withhold that payment.
Yeah, and in some cases, the clause might not be as wide to say that there's no set-off in relation to particular types of claims, but then others there might be a right to set off. And what you see with a lot of terms and conditions is they might provide for some kind of a regime with dealing with complaints, is that there can be a withholding of payment if a complaint's made within a certain time. There's then a process in dealing with that complaint. So that might be a fairer and more balanced way to deal with a particular term like that. But in this particular case, they said because of the nature of the goods, what's being disputed, it's fair, it can stay in. No real consequence here of it being fair or unfair in the context of this matter, again, because of the nature of what the claim was. So this particular one potentially could have affected the outcome of the case around a question of whether there was a breach and a termination. So this one says the delivery period quoted commences from the date Lowbucks receives the required deposit, with any time specified by Lowbucks for delivery of the goods is an estimate only. Lowbucks will not be liable for any loss or damage incurred by Wilshorn as a result of delivery being late. Fair? Hands up or stand up?
trick us each time.
No, there's no tricks.
How late was it? Was it like a day late or was it like 6 months late?
It's a little bit late. It's a little bit late.
It's a little bit like the lawyer's term. It's set in lawyer's terms.
Yeah.
It was a little bit late.
Was it
Fair.
environmental conditions made it late?
Is it floods or storms?
I don't exactly know why it was late. Yeah, I only read
You
it.
can't give yourself cover for late, because late could be 5 years late.
Yeah, but yeah, it could be like,
Just like our submarines are going to be late.
Yep.
During COVID, we had one problem with supply issues.
Yep.
So therefore, we had to let our customers know. This is an estimate. This is what our supplier is telling us.
Yeah.
So this is when we can expect it, or we can go on by what we've been told.
and what's the reasonable amount?
And
You don't get what's the
and
reasonable.
Yep.
what we can do is advise the customer and say, do you wish to go ahead with the purchase of this product? If not, would you like us to look for an alternative? That's what you make that discussion, have that discussion with your customer before you actually get the deposit paid for.
Would it be unfair if it doesn't give the customer an out?
To have that conversation
be?
about, would it be unfair because it doesn't give the customer the option to, if it is going to be late, they can have that conversation and choose whether they go ahead or not with the purchase still, or?
Potentially.
Okay. That's what I got.
That's what you say to the customer, when you quote it, this is the estimated time, and you ask them whether or not that is reasonable, and if they don't want to go ahead with it, you don't accept the deposit.
Yeah.
So
Could
it's
they claim that situation, oh, we didn't actually get told that, but we agreed to sign to the commission at the time, and that's the
Yeah, they're taken to have
conversation.
read them and understood them.
So this clause is just in relation to loss of damages. Was there other clauses that allowed for termination
Yep.
for an event like this?
Yeah. There's terminate, yeah.
I would say it's fair.
Yeah, this one was fair.
Was fair.
This one was fair. And some of the commentary around it was more so in that, I think, Tammy, as you're saying, like for the supplier, they couldn't necessarily guarantee any particular date. This was the best that they could. Again, the stuff that was coming in was relatively specialised. So they couldn't say for certain that this would be when this would be supplied, and sort of said if the parties wanted to agree on time being of the essence and a particular date being the delivery date, they can agree to that. But in this scenario where they just said it's an estimate, we're not liable for that, it doesn't restrict the customer's ability to get out of the contract. It doesn't say that you're just stuck in for a period for whatever and there's no way out for you. So yeah, this one they said that's fair. This is a long one. I'm not going to read it out in its entirety, but what it relates to is there was no dispute that this contract had a retention of title clause in it. So if everyone knows what that means, until payment in full has been made, title to the goods doesn't pass to the customer, so the supplier owns them until they're paid. These rights are ancillary to really that particular right, in that it allows then the supplier with rights to retrieve that asset, go onto property, take it back, restricts the customer's ability to deal with that asset because they don't own it. The argument that was made by the respondent was that this was an extension of the security claimed and really was excessive. It went too far to protect their legitimate business interests. Fair or unfair?
Stand up if you think it's fair. Sit down if you think it's not.
No one wants to stand up. You can put your hands up.
I'm standing up.
You just think they're all fair. Fair? Fair? Couple of fairs. Anyone think it's unfair and want to say why? No. Consensus on fair? Yep, it is fair. It is fair. And the court's rationale around it was you've got this right with your retention of title. These rights then flow from that. It doesn't really go so far to tilt the balance so far in favour of the supplier. These rights make sense to protect their interests in the event that they supply this, they haven't been paid for it. Their retention of title doesn't really have a lot of weight, and you end up in this position where you've got to sue to get it back if you can't exercise these rights. So the court basically said it's fair for them and balances their interests. So I've got one more on this. Standard charging clause, relatively standard charging clause in their terms and conditions. So if you don't pay, you charge all of your assets. We can, let's say, lodge a caveat over your property to get paid. Fair, unfair?
It should be fair.
I'm going unfair this time, guys.
Well, it's going to be unfair. Just have a couple of fairs.
Couple of fairs in a row.
You know, it's an unfair in there. I reckon it's, yeah.
Yep.
It's an unfair.
This, did you have a comment?
Would you like me to say why I think it's unfair?
Yeah.
Okay. Previous to this law, this was always a fair contract in all of the businesses I've worked in. But under the new scenario, it depends on the type of business you're dealing with. Are you dealing with a small business or a large business? Are you dealing with somebody who is not as educated in regards to aspects of contract law? And therefore, if the person was illiterate, even though they signed the contract, it could be considered an unfair clause.
I agree with Carla. I think that charging clauses are scary to a lot of customers. They don't understand them, and the supplier often slips them through. The debt is not significant, and yet they're charging, assets, but the whole business in a lot of cases, without being aware that that's what they're doing.
Yep.
If you're a multinational, you've got lots of money in your back pocket. If you're a small trader who's a small construction block layer and his big contracts are $5,000, this is so unfair on him. If I was in my position as a credit manager for a national company, I'd be going, no, this is fair. But thinking outside the box as somebody who's not, this could be construed as an unfair contract.
Sorry, this is probably going to offend a few people, but I feel if you're going to sign any document, you shouldn't be signing your life away. You should actually be reading that document and understanding it, because a lot of these smaller businesses also have accountants and they use them to do their books. So no, but they should, kind of thing. I don't know. That's just me, because I think that's ignorance. And if you're signing something away and you're a director of a company and you're willing to sign that, you should be understanding what you sign.
I mean, there is that clause within, the understanding that ignorance is no excuse when signing a contract, but I'd say there's still going to be some people out there that can use this to get out of it.
And if you don't understand the clause, get legal advice.
Yep.
What's the answer?
This was unfair. And I think important points raised around the room around it, but I think the thing to keep in mind with this is this was specific to this particular contract, these particular sets of facts. This isn't a blanket. A charging clause is unfair in every single small business contract you'll ever come across. What I think part of the issue here was as well, it probably wasn't really fully argued by the supplier because of what they were claiming. They just wanted their tank back. The outcome of whether this was fair or unfair had no bearing on the case. So what the court said was they hadn't discharged their onus of showing that this was necessary to protect their legitimate business interests. They might not have just run that because they didn't really need to win the case. And the comments from the court around it were, it's not very clear the way it's written. What does, or anyone, I suppose, just off the street may not particularly understand what rights, title and interest in any land, realty or other assets means. It might mean nothing to them, or what does a charge mean to them? They might have no idea. And it was just excessive in that particular set of circumstances. So I think, as you say, Carla, maybe a small account, you might have a particular clause like this is unfair, but if it's something that's more significant and you can show that your interests are protected by this, because if you supply something, for example, like, let's say concrete goes in the ground, you're never going to get any of it back under any other security. Your guarantee and charging clause, or charging clause if there's one in the principal agreement, may be your only prospect of a recovery in that particular scenario. So it may be more in the legitimate business interests that stands in that particular case. But in others, where you might be supplying something where a retention of title might get you your stuff back, it might be something that's generic that you can resell to cover your loss there. You don't actually suffer much loss at the end of the day. It might then be unfair to say, well, you can lodge a caveat and apply to the court to sell the guarantor's property because they didn't pay you 10 grand when you can just get the stuff back and resell it. So every single contract is assessed on its own merits, and it's on the supplier to show in that particular contract why that particular clause was necessary to protect their interests.
So the provision of, say, a purpose-built lift or something like that would be something which would lend itself to that being considered fair?
Yeah, potentially, yeah.
Because you may not be able to resell that type of, or repurpose that type of,
anything sort of custom that you can't do anything with, getting it back might be scrapped to you. And your only recourse on it, and it might be a relatively expensive asset that you've got to outlay significant amounts to manufacture and produce. The risk for you is significant in the event of a default and non-payment, so you need something like this in there to protect that position. The only comment on it is really just the drafting and making it more clear, probably bringing it to the attention of whoever's signing the document a little bit more than just having it hidden within is the better way to deal with something like that, and saying that this is what you're signing up for. We need this in there to protect us because we can't get anything else in the event of a default. So those are just a few, and I just raise them because there is no size fits all. You've got to look at the particular circumstances. Some of the practical implications that we potentially see flowing from here: threats of complaints to the ACCC just to avoid payment. We're not going to pay you this because your terms have got unfair terms, and then we'll go and tell the ACCC about it, and you're going to be up for a 50 mil fine. Drop your case against us, we're not paying you. Defences, we see defences already with just things in there like this particular, like the low bucks case, where there's clauses raised that are unfair that have no actual bearing on the outcome. If we say we're not even relying on them, you still owe this amount, we're happy to say that those clauses are out, still get a defence filed, you've still got to incur the costs of pursuing it through. So there's likely going to be additional due diligence by credit providers. You're going to have to assess whether, if we're talking again about something like a charging clause or your security, whether that is protecting your interests, whether that's sufficient, what you need there. And using those resources like you've got with the BICB, like Lynn's going to be talking about, to assess what the risk profiles are and what you might need in particular circumstances, what you might be comfortable with around limits and all of that to protect your position, and maybe just some uncertainty around whether your security is actually going to be valid at the end of the day. This was just one I mentioned where, as I said, we're seeing defences of this type of thing already. So there's going to be more of it, probably coupled with those threats that the ACCC will come knocking if you don't drop your case. couple of extracts from the defences that we've seen on these, where they just get thrown in. The one down the bottom, for example, just the whole thing's void because of that, without actually applying the legislation, which just says that particular term is void, not the entire contract. We see defences where they just say it's got an unfair term in it, the whole thing must be thrown out, which just isn't the case.
But in theory, the capacity for a contract to actually be rendered useless is possible if there's enough clauses that are deemed to be unfair, isn't it? And that's my question, is what happens to the contract then?
Yeah, there is a section in there that deals with the entire purpose of the contract can't necessarily be frustrated by these terms. So, yeah. So it does provide for that to not render the whole contract completely useless if it can't perform, without certain clauses in there. And these are just some of the key takeaways that we'd recommend is educate your team. Everyone in your team should know about this coming in and what to look for in particular terms. They might not even be the terms that you're sending out. It might be stuff that you're getting in and your team assessing what's coming through the door as to whether there are potentially unfair contract terms. What we commonly see is you might send your terms and conditions out, credit application, whatever it is, contract. You might get a purchase order back with some terms on the back of it. They might have unfair terms in them. You're going to have a fight about what forms part of the contract and whether there are potentially unfair terms in them. So it's not just what you've got in your own contractual suite of documents, it's what you're getting through the door in response. Obviously, updating your own T's and C's is the simple way of dealing with this. And as I've mentioned, a lot of these terms, you don't necessarily need them so weighted in your favour to still achieve what you need to protect your interests in the event of a default. It just so happens that when the changes came in 7 years ago, a lot of suppliers just said, the effect of it is that the term is just void, so we'll just leave it in, and if it falls away, great, whatever. It's not going to really impact us in terms of enforcing the entire contract. It's just some rights that we might not necessarily be able to rely on, but you can't really do that now with the prospect of the penalties in place. You can't just run the gauntlet like that and hope that the ACCC never sees what you've got.
That was the driving factor in terms of upping the penalties, that the people were just playing,
just ignoring it.
A bit of a Russian roulette. Doesn't matter. We'll just leave it the way it is, and if it falls away, it falls away. It won't have any practical implications on it.
Absolutely, and that's where you see, like in a lot of the cases that have been prosecuted, they're all by consent most of the time, where the supplier just says, "Yep, we agree that all of these terms are unfair. Let them fall away." They don't have. There hasn't been that many cases actually argued on the points of whether these are. A lot of them are by consent. And there's just an opportunity for managing your customer relationships, knowing your customers, to assess whether that is protecting your legitimate business interests. You can't do that if you don't know your customers. And again, use those resources that you've got available. Lynn's going to touch on a few to be able to assess and understand what's going on with your customer, to then see what do you actually need in your terms and conditions to protect yourself here based on, particular risk profiles and monitoring and all of that. So same with the BICB, if you're looking at stuff where you might not include a charge at the outset because you don't need it, it might get to a point where there's a lot of defaults, they're slowing down. You might then go to your customer and go, okay, we need some security now to cover ourselves because it didn't make sense at the outset, but it does now. Couple of quick points, 9 November 2023, don't forget the date. Almost 99% of businesses, small businesses, you're not going to be able to escape this. Pretty much every contract that you deal with is going to be one of these. It's not a high threshold, really. It's not a difficult one to get over, and a lot of the legwork falls to the supplier to establish that it's not unfair. 50 mil for each contravention. It's not just one, it could be a couple of hits of that, so you can't avoid it. And these are just a couple of points to, I think, take away and consider, take back to your businesses and look at before 9 November to make sure you're in the best position before this comes in. But the simple way to do that is review what you've got get it updated, make it fair. It's not difficult. And just engage with your customers where you need to understand what you need to protect, where your risk is at, to put yourself in a position to then still be able to enforce your rights in a fair way and recover what you need in the event of a default. That's me, guys, literally. If there's any other questions, happy to have a chat now or even after the seminar, if there's any questions around that stuff. All good. Thank you.